worth it to come here just to be called the new kid on the block. I appreciate that. So I was thinking, how can I introduce sex and drugs in a talk on immigration law? And I couldn't come up with anything. So instead, I want to begin my presentation with a slide. You've all been looking at the screen with black and white script on it for the last hour and a half. So I'd like to start with this. Color. Are you able to read it in the back? If not, I'll read it to you. There's a picture of an individual talking to some sort of an animal at the bottom right of the first box. He says, "Whoa, my friends Henry and Clara are moving to Canada." And the little animal responds, "Well, that sounds interesting." And he says, they sound interesting." And the individual replies, "They are." And the little fellow on the right says, "So, are they in the witness relocation program, or are they just fugitives?" The individual responds and looks at him quizzically. He says, "You seriously can't think of any better reasons to move to Canada?" And the little animal responds, "High-yield snow farming?" Okay. Go back to the first one. So, first of all, you won't find me in your program. As Megan mentioned, I've just joined the firm, and we're going to expand and enhance the immigration law practice. We will be practicing both in the Canadian immigration field as well as the U.S. immigration field. I joined the firm after this program was approved both by the HRPA and by the Law Society. So the program could not be changed, but the firm was kind enough to give me about 5 minutes just to speak to you very briefly. First of all, before I provide some comments, can I ask you please, how many of you, and I won't single anybody out, I won't ask anybody any individual questions, but how many of you, by a show of hands, deal with immigration issues in your firms? So a handful of people. Okay. Well, I'll make some general comments that all of you will be able to appreciate, whether or not you're involved with immigration within your companies. To say that 2013 was an eventful year from an immigration perspective is a bit of an understatement. Many of you will remember in April of 2013, a certain bank, which will remain nameless, brought into Canada a number of foreign workers from India, the purpose of which was to introduce offshoring programs so that the company, the bank, can reduce the number of employees employed there. And the Canadian employees went to the press, and I'm sure all of you remember this went on for weeks and weeks and weeks. The press had a field day. And as a result, immigration reacted, some would say in a knee-jerk manner. I didn't say that, I'm quoting others. And began to slowly implement more restrictive measures. So toward the end of April, they eliminated certain parts of the foreign worker program, and in July they implemented other measures, and finally, believe it or not, on New Year's Eve, on December 31st, regulatory amendments were introduced with sweeping ramifications. So for example, as a result of the December 31st amendments, immigration now has sweeping powers to compel disclosure by employers, and they can enforce serious consequences for non-compliant employers. Immigration has the power now, under the immigration regulations, to conduct warrantless searches of employers' premises and to arbitrarily interview even Canadian citizens who are employed there. In the past, there was this notion of what they called ECRs, employer compliance reviews, but it was quite limited. It was only implemented or instituted in the context of an application, an immigration application by an employer. For those of you who know, I'll use the acronym LMO in the context of a labor market opinion application, and they could only go back 2 years in the employer's records. As a result of the amendments at the end of the year, they now have power to go back 6 years, and it doesn't necessarily have to be in the context of an immigration application. They can pick any employer they wish and arbitrarily walk in the door and make demands. So it remains to be seen how all of this will fall out and play itself out in 2014. But certainly those of you who have foreign workers can take certain steps, and we can be of assistance with devising internal compliance programs, just to make sure that if immigration does walk in one day, you are completely compliant. I neglected to point out one of the sanctions which they have power to impose now is put the name of the employer on a public website and keep it there for 2 years. Okay, so that's one thing that you should be aware of. I'm just going to run through a few factors, a few points very quickly in the few minutes that I've been allocated. It is my intention, the firm will be coming out with a newsletter in February, and it's my intention to provide a detailed article on some of these issues which I'm surveying right now. Also, by the way, there is an article of mine in your materials on spousal employment. I did a bit of a comparison between the Canadian provisions and the U.S. provisions. I just wanted to point it out to you. Some other changes that we have to look forward to in 2014 are those of you who are aware of the intra-company transferee rules, multinational corporations which move managers, executives, or specialized knowledge employees around the world or from around the world into Canada. All of that is being revisited and revamped. We don't know exactly what the final regulations will look like, but again, that's something to look forward to in 2014. Very important point that you should be aware of. In 2011, in April of 2011, the government implemented a new law setting a maximum or a cap on the number of years that a foreign worker can work in Canada. That was 4 years. Now, there are a lot of exemptions to that. I'm not going to go into them. But generally speaking, there is a 4-year maximum cap. Now we're into 2014. That will be the 4th year from 2011 when this commenced. And in April of 2015, those employees who were working or who already in April of 2011 or who commenced employment at that point will be unable to renew their work permits, again, with certain exceptions. So companies have to plan ahead now. 2014 is the right time. You can't leave this until April of 2015 because you will have run out of time. There are strategies which can be implemented, such as having the employee apply for permanent residence, switching the employee from one category to another, but these are the types of things that you have to plan ahead for, and 2014 is the time to do that. A couple of other, or I'll just conclude with one other change. The age of dependency was supposed to change on January 1st, and for some reason it did not come into effect. Again, we don't know the exact date, but you can bet your bottom dollar it's going to be at some point in 2014, and the immigration may give us 24 hours notice. Currently, the age of dependency is under 22 years of age. So if you have a foreign worker bringing a child with, who is under 22 years of age. That child is included in the application and may, without any documentation, attend school and derive other benefits. The new age of dependency will be under 19 years of age, so it drops from under 22 to under 19. And children in that spread between 19 and 22, or 19 and over for that matter, will have to be looking at alternative strategies to remain with their families in Canada. Very important point. So a lot to look forward to in 2014, and a lot of important planning to be done by HR professionals. I thank you. I will be here at the end for any questions, and be happy to provide my information. I think you have it in the paperwork. If anyone has any questions, please feel free to call or email me at any time. Thank you.